हेलो एवरीवन, मैं अभिषेक चौधरी और आज मैं आपके सामने लेकर आया हूँ लॉ से रिलेटेड 50 मिसलेनियस क्वेश्चंस जो कि हमारे लिए अगर हम यूजीसी नेट लॉ का एग्ज़ाम देने वाले हैं या फिर किसी भी यूनिवर्सिटी का पीएचडी एंट्रेंस जो कि लॉ से रिलेटेड है वो देने वाले हैं, तो उसमें ये सारे क्वेश्चंस बहुत ज़्यादा हेल्पफुल रहने वाले हैं। सो आज हम इन क्वेश्चंस की प्रैक्टिस करेंगे और हम इसी तरीके से अलग अलग सेट्स ऑफ क्वेश्चंस जो हैं वो अपनी इस सीरीज़ में प्रैक्टिस करने वाले हैं। ठीक है, सो लेट्स स्टार्ट। आज हम अपना फर्स्ट क्वेश्चन से स्टार्ट करते हैं एंड आवर फर्स्ट क्वेश्चन इज़ assertion and reason based. So assertion is powers and functions are distributed between the two tiers of government under the written constitution in India. And the reason for that is given as union and the states are completely independent of each other under the Indian constitution. And we have given four codes. The first code is assertion is correct and reason is the correct explanation of assertion. Second option is assertion is correct and reason is not the correct explanation of assertion. Option third is assertion is correct but reason is wrong, and option fourth is assertion is wrong but reason is correct. So our answer to this question is option 3, which says that assertion is correct, which means powers and functions are distributed between the two tiers of government under the written constitution in India, but the reason which is given for that assertion is wrong. Okay, so our next question is which of the following is not correct regarding legislation and precedent? Option Option 1 is legislation reflects the formal will of the state and precedent has its source in judgment of court. Option 2, legislation is the formal expression of new laws by legislature and precedent is the creation of law by recognition. Option number 3, legislation is general declaration of law in abstract form and precedent is the manifestation of law in action. And our option number 4 is legislations are based on the minority opinion and the precedents are created or based for future decisions. So our correct option in this question is option number 4, which is wrong regarding legislation and precedent. So our next question is match the following type. So we have given two lists, list 1 and list 2, for which we have given separate codes. So let start. In list 1 we have given article 329 option, and B is 10th schedule part 7, and C is article 31C, and D is article 13 subclause 2. And list 2 we have given some case laws which is related to these options given in the list 1. So the correct option to this question is option number 2, with the code for which is given as 3421. So let's match. Article 329 is related to Indira Nehru Gandhi versus Raj Narayan case. 10th schedule part 7 is related to Kihola versus Jakhilu case, and Article 31C is related to Keshwananda Bharati versus State of Kerala case, and Article 13 subclause 2 is related to Golaknath versus State of Punjab case. Okay, so our next question is in which of the following cases the Supreme Court has held that the word law in Article 21 does not mean merely an enacted piece of law but must be just, fair and reasonable law. So we have given four options. Option 1, A.K. Gopalan versus State of Madras. Option 2, Maneka Gandhi versus Union of India. Option 3, both A and B. And option 4, none of the above. And the correct option to this question is option number 2, which is Maneka Gandhi versus Union of India. Now the next question is which cannot be done directly, cannot be done indirectly. This statement epitomizes the doctrine of option 1, colorable legislation. Option 2, patent substance. Option 3, harmonious construction. For option 4, eclipse. And the correct option to this question is option 1, which is colorable legislation. Now the next question is, which of the following case is not related to theory of basic structure under Article 368 of the Constitution? Option 1, Minerva Mills versus Union of India. Option 2, Vaman Rao versus Union of India. Option 3, L. Chandrakumar versus Union of India. For option 4, T.K. Rangarajan versus Government of Tamil Nadu. And the correct option to this question is option number 4, which says T.K. Rangarajan versus Government of Tamil Nadu. Now the next question is assertion and reason based. Assertion is a person shall be disqualified for being chosen as and for being a member of either House of Parliament if he holds any office of profit under the government, and the reason for which is given as if pecuniary gain is receivable in connection with the office, then it shall not become an office of profit, irrespective of whether such gains are actually promised or not. So for these we have given 4 codes, and the correct option to this question is option number 3, which says assertion is correct and reason is incorrect. So up to the next question. Next question is, right to life under Article 21 of the Constitution does not include right to die. This observation was made by the Supreme Court in option 1, P. Rathinam versus Union of India. Option 2, Gyan Kaur versus State of Punjab. Option 3, both A and B. For option 4, none of the above. And the correct option to this question is option number 2, Gyan Kaur versus State of Punjab. Now the next question is, under Article 14 of the Indian Constitution, the term equal protection of laws has been taken from the option 1, American Constitution. Option 2, British Constitution. Option 3, Australian Constitution. For option 4, Canadian Constitution. And the correct option to this question is option number 1, which is American Constitution. Now the next question is, National Commission of Minorities was established under which of the following provisions? Option 1, Article 328 of the Constitution. Option 2, Article 328A of the Constitution. Option 3, Section 3 of the National Commissions of Minorities Act 1992. For option 4, Article 280 of the Constitution of India. And the correct option to this question is option number 3, which is National Commission for Minorities was established under Section 3 of the National Commission of Minorities Act 1992. Now the next question is match the following type. We have given 2 lists. In the list 1 we have given some doctrines, or to say some concepts, and in the list 2 we have given the names of some jurists. So list 1 option first is pure theory of law. Second, 3 lectures on Vedanta philosophy. Third, judiciary attacks and survivals. Option D, the growth of law. These all are the name of the books which have been written by these jurists. So we have to match the correct book name with the correct jurist. Okay, so the correct answer to this question is pure theory of law has been written by Hans Kelsen. 3 lectures on Vedanta philosophy has been written by Max Mueller. Judiciary attacks and survivals has been written by Justice V.D. Tulsapurkar, and the growth of law has been written by Justice Cardozo. So the correct option for this question is option number 1, which says 1, 2, 3 and 4. Okay. Now the next question is, no one has any other right than always to do his duty. It was stated by option 1, Kelsen. Option 2, Professor Duguid. Option 3, Holland. Option 4, Salmon. And the correct option to this question is option number 2. This was said by Professor Duguid. Now the next question is assertion reason based. Assertion is a perfect duty is one which is in which a person not merely ought to perform but may be justly compelled to perform, and the reason for that is given as a perfect duty is one which is not merely recognizable by law but enforceable. And the correct option to this question is option number 1, which says that both assertion and reason are correct, and reason is the correct explanation of the assertion. Okay. Now the next question is, which of the following statements are correct in regard to a valid custom? We have given 4 statements and we have to choose which of these statements are true. Okay, so we have multiple statements which are true. Now let's just see the statements. Statement number A is the custom has to possess a sufficient measure of antiquity. Okay, now the next statement is the custom must have been enjoyed as of right. Third statement is the custom need not to be consistent with other custom in the same area. And the fourth statement is the custom must be certain and precise. So the correct option to this question is option number 4, which says that A, B, C and D, all the statements are correct regarding a custom. Okay. Now the next question is, Constitution is both a matter of fact and a matter of law. This is a book, and who is the author of it? We have 4 options. Option number 1, A.V. Dicey. Option number 2, John Austin. Option number 3, Salmond. Option number 4, Hans Kelsen. And the correct option to this question is option number 1, A.V. Dicey is the author who has written the book Constitution is both a matter of fact and a matter of law. Now the next question is, according to Salmond, the correlative of liberty is option number 1, duty. Option number 2, no rights. Option number 3, subjection. Option number 4, disabilities. And the correct option to this question is option number 2, which is no rights. Now the next question is, right to divorce is option number 1, right in stricto sensu. Option number 2, liberty. Option number 3, power. Option number 4, privilege. And the correct option to this question is option number 1, which says right to divorce is a right in stricto sensu. Now the next question is assertion and reason based. So assertion is given as marriage under Hindu law was indissoluble, and the reason for that is given as marriage was regarded as sacrament. And we have given 4 options. So the correct option to this question is option number 1, which says that both assertion and reason are true. So it is true that marriage under Hindu law was indissoluble because it was regarded as a sacrament. Now the next question is, marriage between a Muslim male and a Christian female under Muslim law is option 1, void. Option number 2, voidable. Option number 3, irregular. Option number 4, valid. And the correct option is option number 4, valid. Okay. Now the next question is, which of the following is not a condition for a marriage under section 5 of the Hindu Marriage Act 1955? Option 1, neither should have a living spouse. Option number 2, if the bride is below 18, the consent of her guardian has been obtained. Option 3, they are not within prohibited degrees of relationship. Option 4, neither should be subject to recurrent attack of insanity. And the correct option to this question is option number 2, which says that if the bride is below 18, the consent of her guardian has been obtained. This has not been mentioned in the section 5 of the Hindu Marriage Act 1955. Now the next question is, match the following type. In the list 1, we have given with certain terms, and in list 2, we have been given with meanings of those terms. So we have to match the term with its correct meaning. So the correct code for this question is code number 3, which says that 2431. So agnate means related wholly through males. Shruti means what has been heard. Cognate means related not wholly through males, and Smriti is what was heard. Okay. Now the next question is prohibited degree and subpender relationships are option 1 mutually exclusive, option 2 dependent on each other, option 3 may overlap each other, if it option number 4 none of the above. And the correct option is option number 3, which says that may overlap each other. Now the next question is the act of causing death of a person who has committed or attempted to commit housebreaking by night is known as option 1 marginal access of right to private defense, option 2 purported exercise of right of self defense, option 3 murder, if option 4 no detached objectivity would be possible to weigh the culpability. And the correct option to this question is option number 2, which says that the act of causing death of a person who has committed or attempted to commit housebreaking by night is known as purported exercise of right of self-defense. Now the next question is assertion and reason based. Assertion is given as culpable homicide becomes murder when the act causes death and is done with the intention of causing death. And the reason for that is given one of the conditions to be satisfied for treating it murder provide the injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. And the correct option to this question is option number 4, which says that both assertion and reasons are true, and reason is the reasonable explanation of assertion. Okay. Now the next question is instigating or engaging in a conspiracy or intentionally aiding a person to commit an offense is better known as option 1 principal crime, option number 2 second degree crime, option 3 willful misrepresentation, या फिर option D option 4 abatement. And the correct option to this question is option number 4 abatement. Okay. Now the next question is assertion and reason based. Assertion is given as the principle of common intention applies when a criminal act is done by several persons in furtherance of that intention. And reason is given as an intentional cooperation for committing an offense culminated from several acts. Now the correct option to this question is option number 3. Both are distinctive offenses and assertion is not dependent on reason. Okay. Now the next question is the maxim de minimis non curat relates to option 1 slight harm, option 2 trifles, option 3 exhibition of disrespect, or option 4 annoyance. And the correct option to this question is option number 2 trifles. Now the next question is assertion is given as damages must be related to damage. Reason is given as damage is damaging and damages are compensating. And the correct option to this question is option number 1, which says that assertion and reason are both true, but reason is not the correct explanation of the assertion. Now the next question is liability in tort depends on option 1 quantum of damage suffered, option 2 involvement of intention, option 3 infringement of legal right, or option 4 effect of public interest. And the correct option to this question is option number 3 infringement of legal right. So there have to be an infringement of legal right, only then we can set the liability in the tort. All these other things are after the infringement of the legal right. Now the next question is a match the following type, and we have been given with list 1 some topics and list 2 some case laws. So The correct option to this question is option number 3, and which says 2143. So plaintiff or wrongdoer is Bird versus Holbrook. Act of God is Nichols versus Marsland. Inevitable accident is Stanley versus Powell, and mistake is Consolidated Corporation versus Curtis. So these doctrines have been settled in these case laws. Okay. Now the next question is D employs a driver Jed to drive his car. Okay, and D specifically instructs the driver not to drive fast and in no case exceed the speed of 50 kilometers per hour. Still, Jed exceeds the limit and causes the accident in which P is injured. In an action against D for damages, we have given certain cases. So first option is D is not vicariously liable for the act of the driver because the driver acted against the express instructions of his master. Option 2 is D is not liable as the act of the driver was not done during the course of employment. Option 3 is D is liable as the driver was doing an unauthorized act in an unauthorized manner. And option number 4 is D is not liable as there was contract for service between D and the driver. So the correct option to this question is option number 3, which says that D is liable as the driver was doing an authorized act in an unauthorized manner. So the authorized act was that he was a driver, he had to drive the car, but in an unauthorized manner means that he exceeds the speed limit which was specifically instructed by D. Okay, so in that case D is vicariously liable. Now the next question is, which of the following is an exception to the rule of strict liability? Option 1, defendant's own fault. Option 2, statutory authority. Option number 3, consent of third party. Or option number 4, act of defendant. And the correct option to this question is option number 2, statutory authority is an exception to the rule of strict liability. Now the next question is, in a case concerning the legality of the threat or use of nuclear weapons, the International Court of Justice gave advisory opinion at the request of option number 1, UN Security Council. Option 2, UN General Assembly. Option 3, World Health Organization. Or option 4, United Nations Education and Cultural Organization. And the correct option to this question is option number 2, UN General Assembly asked for the advisory opinion in the case of legality of the threat or use of nuclear weapons. Now the next question is, which of the following is not a primary source of international law? International treaty, it is a primary source. Decision of International Court of Justice. Option 3, international custom, it is a primary source. And general principles of law recognized by civilized nation, it is also a primary source. So which is not a primary source? Option number 2, decision of International Court of Justice. Now the next question is, United Nations Commission on Human Rights has been discarded and replaced by option 1, Economic, Social and Cultural Rights Committee. Option 2, Amnesty International. Option 3, Human Rights Committee. If it option 4, Human Rights Council. And the correct option is option 4, Human Rights Council. Now the next question is, doctrine of forum prorogatum means. Option 1, jurisdiction cannot be conferred upon an existing tribunal not otherwise competent by the litigants during the proceedings. Option 2, jurisdiction can be conferred upon an existing tribunal not otherwise competent by the litigants during the proceedings. So option number 2 is correct, but we will also read option number 3 and 4. Option number 3 is jurisdiction can be conferred upon an existing tribunal not otherwise competent by the litigants after the proceedings. So jurisdiction can be conferred upon an existing tribunal, but it has to be done during the proceedings. Okay. Now the next question is, Estrada doctrine relates to option 1 necessity of recognition, option 2 form of recognition, option 3 no necessity of recognition, option 4 recognition is superficial. So the correct option to this question is option number 3, which says that no necessity of recognition. Next question is, the state is the trustee of all natural resources which are by nature meant for public use and enjoyment, and that Indian legal system includes the public trust doctrine as a part of its jurisprudence. This has been a statement observed by the Supreme Court. So we have to tell in which case this statement has been observed. Option number 1 is T.N. Godavarman Thirumulpad versus Union of India. Option 2 Indian Council for Enviro Legal Action versus Union of India. Option 3 MC Mehta versus Kamalnath, and option 4 Sri Sachidananda Pandey versus State of West Bengal. So the correct option to this question is option number 3, which is MC Mehta versus Kamalnath was the case in which this statement about the public trust doctrine was observed by the Supreme Court. Now the next question is assertion and reason based. Assertion is, it is the duty of the state to devise and implement a coherent and coordinated program to meet its obligation of sustainable development, and the reason for that is given as adherence to the principle of sustainable development is now a constitutional requirement. So the correct option to this question is option 1, which says assertion and reason are both true, but reason is the correct explanation of A, assertion. Now the next question is, in which of the following case the Supreme Court of India held that right to access to drinking water is fundamental to life and it is the duty of the state under Article 21 to provide clean drinking water to its citizen? Option 1 Vellore Citizens Welfare Forum versus Union of India. Option 2 Narmada Bachao Andolan versus Union of India. Option 3 MC Mehta versus Union of India, or option 4 Karnataka Industrial Area Development Board versus Sri C. Kenchappa. And the correct option to this question is option 2 Narmada Bachao Andolan versus Union of India. Now the next question is very simple. When was the National Human Rights Commission constituted? Option 1 1992, option number 2 1995, option number 3 1996, and option number 4 1993. So the correct option is option number 4 1993. Yeah. So next question is, guidelines for arrest of persons by the police were given by the Supreme Court in which of the following cases? Option 1 Menaka Gandhi versus Union of India. Option 2 Otto Sankar versus State of Tamil Nadu. Option 3 Hussain Ara Khatun versus the State of Bihar, or option 4 DK Basu versus the State of West Bengal. And the correct option is option number 4, which says DK Basu versus State of West Bengal was the case in which some guidelines were given by the Supreme Court related to the arrest of persons by police. Next question is, in which of the following cases the minimal creativity test was laid down? It is related to the IPR. So option 1 is Eastern Book Company versus DB Modak. Option number 2 RG Anand versus Deluxe Films. Option 3 Amarnath Sehgal versus Union of India. Option 4 University of London Press versus University Tutorial Press. And the correct option to this question is option number 1, which says Eastern Book Company versus DB Modak. And the next question is, the UNCITRAL Model Law on Electronic Commerce was adopted by the United Nations Commission on International Trade Law in 1996 in furtherance of its mandate to option 1 reinforce protectionism in matters of international trade. Option 2 promote the harmonization and unification of the law relating to international trade. Option 3, increase the share of services in international trade. Option 4, increase the role of shipping in international trade. And the correct option is option 2, promote the harmonization and unification of the law related to international trade. Next question is, software is protected as intellectual property in India primarily under the law of option 1, industrial designs. Option 2, geographical inductions. Option 3, trademarks. Or option 4, copyright. And the correct option is option number 4, copyright. Okay. Next question is, through which of the following cases was Section 66A of Information Technology Act 2000 struck down by the Supreme Court of India? Option 1, Supreme Court Advocates on Record Association versus Union of India. Option 2, Ram Singh versus Union of India. Option 3, Rajbala versus State of Haryana. Or option 4, Shreya Singhal versus Union of India. And the correct option is option number 4, Shreya Singhal versus Union of India. Next question is assertion and reason based. Assertion is, a contract is a property in the nature of a promise supported by some consideration upon which either the remedy of specific performance or that of damages is available. So it is basically a definition of the contract, and reason is given as, above principle is laid down in Sunrise Associates versus Government of NCT of Delhi. And the correct option to this question is option 2, which is both assertion and reasons are incorrect. Okay. The next question is, supply of necessaries to a minor is option 1, contract. Option 2, quasi contract. Option 3, tort. Option 4, legal contract. And the correct option to this question is option 2, which says it is a quasi contract. Next question is, basically we have been given with 4 statements, and we have to arrange them in a sequence in which they have appeared, in which they normally appeared in a normal case. Statements are, first, offer by X to Y. Option statement 2, undue influence of X over Y. Option statement 3, demand of damages by Y from X. And 4 is acceptance of the offer by Y. So the correct code to this question is, first there will be an undue influence, then there will be offer by X to Y, then there will be acceptance of the offer by Y, and after, in the last, there will be damages, demand of damages by Y from X. So the correct option is option number 3. The sequence is 2, 1, 4 and 3. Now the last question of this series is, an agreement made by mistake is option 1, void. Option 2, voidable. Option 3, illegal. Or option 4, immoral. And the correct option to this question is voidable. So if you have ever entered into an agreement which is by mistake, you can always void that agreement, because that is voidable in nature. Okay. So with that question we end this series of MCQs on law subject. I will be continuing with another set of questions which will be helpful for you guys in several of examinations like UGC NET, PhD entrance, or various legal type examination in all sorts of organizations, be it SEBI legal officer, or be it like JLO, or any other kind of examination in which you are required to have legal knowledge. Okay, so keep connected with me, subscribe to this channel, share this channel, and watch these videos as many times as possible. You can also practice it as a mock series. Okay, so thank you very much, and all the very best to all the aspirants who are looking to give examinations in your near future. I will always be there to help you guys in all the aspects I can. Okay, thank you so much.